SJC-11925, Guardianship of B.V.G.
Mr. Martin, good morning.
Good morning, Your Honors. May it please the Court, together with attorney Jennifer Michaels, we are pro bono counsel to Mr. Leonard Klein, the appellant in this case. This is a case that raises two issues of first impression for the Court. The first one, as you framed it, was whether a grandfather can qualify as an interested person within the meaning of the Massachusetts Uniform Probate Code, which I'll refer to as MUPC, where that grandfather has no financial or other tangible interests in the guardian proceeding of his adult granddaughter, and he seeks to rekindle his relationship with her. With respect to that issue, the appeals court correctly answered yes. The second issue asks whether such interested person is necessarily entitled to intervene as a matter of right in such guardianship proceeding.
Before we get beyond the first question, is the answer yes just by virtue of relationship or yes as a factual matter? And if it's the latter, wouldn't there need to be, I mean, there was no hearing here, wouldn't there need to be a hearing about that?
I believe that the appeals court was quite ready to accept from the record sufficient facts to determine that Mr. Klein was in fact an interested person. It had in the record before it his evidence, if you will, present in the form of our brief, that he'd had considerable amount of, if you will, interchanges.
How was that presented in the probate court?
We filed a motion to intervene, Your Honor, and we attached to it evidence from Mr. Klein himself.
So an affidavit?
I'm sorry?
Was it an affidavit?
It was not in the form of an affidavit, but we, as officers of the court, represented that this was, in fact, the truth. And the judge at the hearing at which Mr. Klein was present had the opportunity, certainly, to ask him as to those matters and was willing to accept them in his decision.
So my question really was whether the, just looking to see where that noise is coming from, but I don't know. In any event, my question really was whether this is a factual question, which the appeals court seems to have sort of treated it as. And would you agree with that? In other words, it's not just by virtue of the fact that
That's correct.
he is a grandfather
That's correct.
with a granddaughter with whom he used to have a relationship. It has to depend on the facts, and it would be up to, I'm not saying he didn't, but it would be up to the proponent of this to establish that to the judge would have discretion over that matter, right?
That's correct, Your Honor. And in fact, the appeals court endorsed the very qualifications for an interested person, because it's the equivalent of a person interested in seriously interested in the welfare and concerned for the welfare of an incapacitated person and knowledgeable of the circumstances. And I believe they were satisfied that we had presented enough evidence to that effect. It's in the record. There was a considerable interchange showing that the granddaughter very much, if you will, wanted to have Grandpa in her life, that he was very responsive and responsible, and he tried very hard, if you will, to act very responsibly to her.
Can I ask just a quick question in terms of how this fits into the role generally of the probate and family court in these kinds of cases? Do you think it's different in a significant way from the, I think, rather generous approach that the probate and family court would take with respect to the next friend category, another similarly broad category of persons who knows who may intervene on behalf of minor children. There's now, it used to be in the statute, it's certainly now codified as a next friend, whoever that may be, but in the decisional law, someone who is interested.
Your Honor, I'm afraid I'm not familiar with the next friend doctrine. However, if I may point out, in the determination of who is qualified here, the court has to be satisfied that there is a real serious interest and concern, and there's some real knowledge. If I may point out, this is distinguishable from the other section of the MUPC, which says that in the 5106D, if you are a person, you're not an interested person, and you have information, you don't have knowledge, then the court has the absolute discretion to impose conditions on whether you can, in fact, petition. This is not this case.
But the court does get to say whether you qualify on the facts presented as an interested person.
It would, in fact, do that. Unfortunately, in this case, Your Honor, the court did not, if you will, establish what was the qualification, and thanks to the appeals court, we now have a better understanding of that.
So this is a procedural question I wanted to ask, though. As I read, I've got to get my statute right, the statute, Section C of whatever that statute is, 5306C, which is what you're coming under, right?
Correct, Your Honor.
So I guess I'm wondering, is it really intervention, or is it, in other words, if there's an ongoing guardianship proceeding, wouldn't you be filing a petition to do this? And I mean, in other words, you wouldn't need to be intervening in the entire guardianship proceeding, would you?
Thank you, Your Honor. I'm like an earlier counsel. I thank you for that question, because we tried to, in fact, present a petition on that very basis of 5306C to the probate court. This was in March 29 of 2013. The registrar called me up on April 9, and he said, we can't accept this petition. If you want to be heard, and in fact there was a hearing available on the 11th, you must file a motion to intervene. So we went back and we recast the 5306C petition in the form of this motion to intervene. And if I might say so, Your Honor, I think that's really created some issues in this case, and I would suggest that you can decide under 5306C without getting to the
Because
question
you had
of intervention.
it's a very limited issue you're
That's right.
trying to deal with, not the entire, however long this guardianship, which in this case may go on for life.
That's correct. And in fact, I think if you look at the MUPC, they describe 3 instances in where an interested person, they really say a person interested in the welfare of, 3 instances where you appear. And it's not clear that if you appear to ask for the guardianship, that you're therefore a party for the entire proceeding. It doesn't make sense. You can also terminate a guardianship. You can remove a guardian. But it doesn't make sense that somebody coming in like we are to just modify would necessarily ask to have the guardian removed. So I agree with you completely. It's not truly an intervention case. And the other reason it's not really an intervention case is that when you look at the rule, you look at Rule 24, what does it say? It says that to protect the interest of the intervener, you can then try to fit within 24A. 5306C is all about protecting the interest of a party that's already in the case, namely the incapacitated person.
So pragmatically, the intervention here was essentially to limit the scope of the guardianship to protect the ability of the grandfather to see the child, to see the adult,
Or to have some relationship.
or to have some relationship.
That's correct. If I might elaborate a little bit, Your Honor, in our original petition under 536C, we presented the case that it would be in the best interests of the granddaughter to rekindle the relationship because she so much yearned for it. Of course, a grandfather wants to have the contacts, but the criteria here is not really his interest, as much as he is interested in having as wonderful a rekindling of contact. It's really what's in her best interest.
Well, but that then poses the conflict with regard to Rule 24, because Rule 24, it says that where intervention is appropriate, it shall be granted unless the applicant's interest is adequately represented by existing parties, which means your interest, not that of the incapacitated adult.
Exactly.
So, what are you saying we should be? What should we? I mean, I know you didn't want to go Rule 24, but you're in Rule 24 for land. Are you saying we really should just abandon Rule 24, focus on 306C, and then the key issue is the interest of the adult,
That's correct, Your Honor.
the person? So that you say that's the crux of it.
That's correct.
But of
for
course,
the very reason
the
that
appeals
Justice-
court says, well, the interests of the adult here were adequately represented by her counsel, and that of the guardian ad litem, and therefore there's no need for you to be here.
Right. And we respectfully submit that was quite an error because they're misreading Rule 24A. In fact, they focus on A2, which makes the judgment as to whether the interests of Mr. Klein, my client, have been adequately represented in this court. Well, the adequate representation, as they point out, is for the incapacitated granddaughter, not Mr. Klein. So they were, if you will, going off, if I may respectfully say, in a tangent that doesn't really help you decide this case. 5306C is the criteria by which we suggest respectfully that you should judge this case.
And you say there you have an entitlement. I've not looked back to that since I didn't realize that was the core issue, but you say there's an entitlement for an interested person to play a role in this proceeding.
Well-
Exactly, that's the way the statute states it.
But that
Your Honor.
would take you under 24A1, which you didn't plead.
Well, we actually did, Your Honor, if I may so correct it. The record, as you observe, will show that in our brief supporting the motion to intervene, we argued for all of 24A, the right to intervene as a right. The judge, in his decision, looked at all of 24, including 24A, and he mentioned it specifically. So it was certainly in the judge's mind that 24A might apply.
Isn't this, put aside for a minute how this actually happened, but if I understand your argument, what you say should happen in a situation like this is your client files a petition, says, I'm an interested person, and I'm filing a petition to limit the guardianship in the sense that to do what you want to do. So the first question the judge has to decide is, on the facts that I have before me, which may be an evidentiary hearing, I have to figure out, A, are you an interested person?
Yes.
And then B, if you are, then I have to figure out whether to do what you're asking me to do, right?
That's correct. And in fact, Your Honor, if you look at the very form that the probate court has promulgated for persons coming in with these petitions, the form asks, are you a person interested in the welfare of this incapacitated person? And it leaves a large blank, and you should state your reasons for so doing. When we created a petition that was rejected, it would not be accepted, we had a rather elaborate, and it was a verified petition. We had Mr. Klein actually provide the affidavit, and it said, here in quite elaborate detail are the reasons why. We weren't going to merely fill in a few spaces in a form.
Yes, yes, I am, right.
Yes, I am, for obvious reasons. I'm a grandfather. And your next question is, what is it that the probate court should consider with respect to the petition? On that issue, I would suggest that the court should not do what the appeals court said and try to make a determination whether there's already adequate representation by a GAL or by a council. That's not what the statute says. But the court certainly should judge the petition what it is, and as we say, if you look at the statute, it says at the end of 5306C, following this procedure. That's a very clear reference to the procedure in 5306B, the procedure for having an evidentiary hearing to determine if a guardian should be appointed. And therefore, as we respectfully suggest, what the court, once it has satisfied itself, Your Honor, that this is an interested person interested in the welfare of the, then they should hold the evidentiary hearing on this petition.
About whether
because
to
it is
limit the
for limitation of
guardianship or not, right?
That's right, that's right.
And to be clear, if that were done, it is your position that if the court were to find that the grandfather loves her very much, but the best interests of B.V.G. are still to be served by him having no contact with her, you would say you disagree with that on the facts, but that is the appropriate analysis.
That's correct, Your Honor. I think it might call for some expert testimony here. This is an incapacitated person. She has a variety of issues, and we think that that would be
Right,
part,
but
if you
the-
will,
but the-
of the factual
But the
record.
core determination for the court is what is in
That's correct.
B.V.G.'s best interest, not what is in the grandfather's best interest.
That's exactly right. And if I may add, when you read the comments for the introduction of the MUPC and you read these particular sections, they hammer home the obligation to give the incapacitated person as much liberty as possible and as much chance to develop as possible. And so, if you will, the entertaining of this petition, I suggest, should be very open to the kind of facts that are productive for what the MUPC is trying to accomplish in limited guardianships.
Okay, thank you.
Thank you, Your Honor.
Good morning, Chief Justice and Associate Justices. My name is Adam Nussenbaum. I represent Dermot Gagan, who is the father and legal custodian of B. I would prefer to just refer her as B instead of B.V.G. It's a little less cumbersome. And I've represented him since 2011. He is a single father who's been the sole custodian of his daughter since 2005. I must admit, Your Honor, that when you indicated that you didn't realize that the core issue related to the statute as opposed to intervention, I didn't realize that either, because to be honest with you, Your Honor, this is the first I've heard of any of these facts regarding the prior court, the intention to submit a different form of petition, the refusal of the court to accept that petition. Nothing was ever submitted in any of the courts, whether it was on the probate court, the appeals court, or this court, that related to any of those facts. No affidavits, no affidavits from either counsel or from the court, no examples, no copies of these petitions, this petition and affidavit that was supposedly filed. So, Your Honor, I have to admit I'm a little bit caught off guard, because I'm all prepared today to address the issue of intervention, which is, frankly, what this case is all about. And so, without getting into any of that...
In the brief, they certainly argue that 5306C plays a big role here.
Absolutely, Judge, and I agree with that. And I'm prepared to address this statute specifically because I think it's extremely relevant. I believe, though, that the issue that is before this court is intervention, which is the procedure by which Attorney Martin and Mr. Klein attempted to come into this case. And I think there's a very significant difference between intervening on an existing case and filing a new limited petition for the purposes that he expressed. The reason that we opposed intervention was because this was a case that was proceeding toward judgment. All the parties had been working together, and we were actually close to accomplishing an objective of a permanent guardianship with specific limitations built into it. And at the 11th hour...
All right, so say you got the permanent guardianship with the specific limitations. Nothing, as I read 5306C, would prevent the grandfather from filing a petition under that section, right?
Absolutely, Your Honor. And in fact,
So?
my opening statement was I was going to say We accept the appeals court determination that Mr. Klein is an interested person, and that that interested person and person interested in the welfare are actually, in fact, synonymous. We agree with this. We've researched this. We agree with that position. But again, the issue has to do with whether an interested person is an interested party. And we believe these are two very, very distinct categories. And we also, our position is that although the probate court and the appeals court reached a different determination as to whether Mr. Klein was an interested person, both of them agreed that he did not have an unconditional right to intervene. And the decision to designate party status was a discretionary decision by the probate court under Rule 24B. The appeals court affirmed that, and we believe that was the correct
4A2
decision.
Isn't it 24A2 that they decided it under?
I believe they decided it under possibly 24A2.
As of right, but checking to see about adequacy of representation of the applicant's interests.
I have to go back and review it again, but I believe they also addressed 24B, but I would have to review that again, Your Honor. I'm not 100% sure on that. Our position about interested person is that the role of the interested person under the MUPC is to bring information to the attention of the courts in order to assist the court in making decisions that are in the incapacitated person's best interest. And in fact, the amicus brief that's filed...
You don't think under C, the person can bring a petition to limit the powers of the guardian?
Oh, we agree with that, Your Honor. We agree that the person can initiate a petition under 5306C in order to limit the powers of the guardian. We agree with that.
Is that what he was trying to do here?
He is, Your Honor, but what our point is that he is not in a position, or the legislature wasn't attempting to confer substantive rights on the individual bringing this petition. We believe what the legislature was attempting to do was to bring forward, allow an interested person to bring forward information so that the court could make a determination about what was in the incapacitated person's best interest.
Isn't there another section that talks about doing that, though? I don't remember what it is, but it was just mentioned by Mr. Martin, that it says may bring information forward? That's not this section.
No, but Your Honor, this section uses the same language of being an interested person. And we're indicating that an interested person...
Well, it's a defined term, isn't it?
It's a defined term which the appeals court said went beyond that actual definition. And in fact, we initially argued it was a limited defined term, but then after reviewing the appeals court decision, we have concluded that it can, in fact, go beyond
It's the last part of the definition, right?
Right, that's right. And the definition seemed to focus on individuals who have financial interests, which we agree in this
But then
particular
it
case,
says
it goes
in
beyond.
other circumstances it can mean something different.
Right. I mean, Your Honor, the problem is if this court confers unconditional party status...
But he's not looking for that. He's not looking for that.
But, Your Honor, what he is looking for specifically is, I agree, is limited. But what this court would be doing if this court expanded and allowed this, the court would be, in essence, saying that any interested person, anyone who has information, has the right to then intervene and be a part of the guardianship proceeding.
If I can just...
Only if we needed to say that Rule 24 had any application here at all. I mean, isn't it possible for us to simply clarify that intervention under Rule 24 is simply the inappropriate procedure for any court to require an interested person under 5306C to follow, and to say the way you do it is the way 5306C says.
Well, that's fine, Your Honor, except that's not what the parties in this case did.
Well, but I mean, you could see from the pleadings that the reason that there is a Rule 24 motion is in order to get to 306.
Right.
And there is a history, I think, at least in that court,
Sure.
that you can, in other courts, conform the pleadings to the circumstances. And nobody's disputing that, you're agreeing that this might be appropriate, right?
I agree, Your Honor. In
No
fact,
statute of limitations?
no, I agree, Your Honor. And we're not arguing today that Mr. Klein has no ability to file a petition under 5306C. We're arguing today that he does not have the right to intervene on the case, because filing a petition, as Your Honor well knows, filing a petition is completely different from intervening as a party. If he were to intervene as a party, he'd have a seat at the table for all matters. I understand that, Your Honor. I understand that what he is saying is he does not want to do that.
Right.
But my point is that his motion sought to intervene in order to have a seat at the table at the guardianship. And that's what was appealed, the denial of that. And that's what ostensibly was before this court on the issue of his right to intervene. It wasn't on the issue of whether he has a right to file a petition under 5306C.
So is this just a grand example of Cool Hand Luke's, what we have here is a failure to communicate? I mean, you're saying that you may disagree as to the merits of whether the grandfather should have contact.
Absolutely.
But if a grandfather in this circumstance says it is important for the incapacitated adult to have a relationship with me, that will help her, there is a way to do that, not through intervention, but through filing this petition under 306C, and then the interest of the incapacitated adult is the core issue.
Well-
and then the person remains the guardian, and the question is whether or not this person is going to be able to limit the scope of the guardianship to allow the grandfather or not to do that. You're fine with that.
I completely agree with that, Judge. The only issue that I would just point out to this court is that in terms of filing a petition, what is required under filing a petition is significantly different from a motion to intervene. So I believe that if he were to file the petition, and the form is very clear that an interested person can file this petition, it would require a statement, it would require information, perhaps an affidavit, all of those things in order to get the foot in the door. But the problem was, by filing a motion to intervene, he wasn't attempting to get his foot in the door. He wanted a seat at the table. We were in the process.
Well, you're saying he does, and we know he did, but you know, I mean, it's also possible, we've all been there, that clerks tell us to do things, and they're wrong.
Right.
But you can't get in the door unless you do it the way they tell you to do it.
Or you can apply to the single justice for,
I know, but I
for
mean-
relief.
But if you think that this is the other way in, you just do it. I mean, you know, so, I mean, what are we really arguing about here?
You know, I apologize for not having thought of this before, but do the rules of civil procedure even apply to statutory probate proceedings?
Yes, Your Honor. I mean, the rules of civil procedure do apply to the probate court. I mean, the
Well,
only
I
other-
know they apply to the probate court, but do they apply to this type of proceeding?
I see no reason why they wouldn't, Your Honor.
Okay.
Perhaps Justice Duffley can answer that question better.
So look, again, that, I don't know about this one. There are rules, and some of them incorporate the other rules, and some
Right.
of them don't, and there's a
Right.
default.
Right, right.
But this is a new question.
Right.
Because it's a new rule.
Right.
I mean, the MUCP's.
Right, I agree. I mean, Your Honor, the only other point that I did want to make in terms of this particular proceeding is that there were things that could have been done in order to further this case that weren't done. I believe it was Justice Bosser, you asked a question about affidavits. There were no affidavits filed. Mr. Klein was present at the motion hearing. He didn't testify. There were no affidavits. Everything was based on representations made by counsel, and that obviously will be relevant or would be relevant at any type of proceeding. But I think it was on the basis of that Judge Phelan, in his probate court decision, took in whatever evidence he had and made a determination that Mr. Klein was not, that he would not permit him to intervene on the case.
But you, at least on that point, as I heard you at the beginning, you would say Judge Phelan was not correct.
No, what I said was that the appeals court made a determination that he was incorrect on one part,
Yes.
which was not defining Mr. Klein as an interested person.
Because he didn't, right, and
Right.
so,
Right.
yeah.
But I believe that the appeals court was correct in making a determination that he was not allowed to intervene, that it was well within Judge Phelan's
Not
discretion.
a matter of right that he could
That's
intervene as
right.
a party.
It was well within his right to say that he was not an interested party and that he did not have a right to intervene. And that's, I believe, why the appeals court affirmed. The only other point, again, Your Honor, just has to do with the parties that are there representing both Brittany, B, and her, she has counsel who is appointed to represent her and who the record clearly reflects has been actively involved in this case, negotiating stipulations. She has a guardian ad litem. So to suggest that somehow they are asleep at the wheel, I think is just completely incorrect and inappropriate to them. Yes, Judge.
Was there a position taken?
So, Your Honor,
I thought the GAL did not take a position.
right. So the GAL, Your Honor, has not taken a position in terms of filing anything affirmatively to promote communications. The counsel's role, as Your Honor knows, is to express B's wishes. And I think it would be wrong to infer from their silence some type of indifference or ineffective assistance. These are people who are actively involved, and they have deliberately chosen not to take affirmative steps for reasons that obviously they feel are relevant to this case.
I thought there was some suggestion that the grandfather's, I'm sorry, that the father's, that the B's counsel just didn't really want to have to deal with grandfather in the case.
A suggestion where with that in appellant's brief?
Someplace that I thought I read
The
that there was.
suggestion that he wanted to try to negotiate something without having it ruled on, or something like that.
Well, no, the only thing I can think of, Justice Lank, that you may be referring to is in appellant's brief, there is some reference that there was a perception that the order appointing the guardian ad litem did not include the grandfather, that the order was limited in scope, which we actually disagree with. Only a portion of the order was reprinted in appellant's brief, but in fact, if you read the order in its totality in referencing the guardian ad litem, it's clear from that order that it does in fact apply to the grandfather as well.
But you're not suggesting that any of these things are a substitute for allowing an interested party under 306C to, in fact, attempt by this petition to bring to the judge's attention.
No, under the way the statute is written.
This is not an alternative.
No, I don't, Your Honor, under the way the statute is written, I don't think there's anything that could prevent the grandfather from initiating a petition under that
He's
section.
an interested person. The judge has already determined, the appeals court has
Well, the
determined.
appeals court did, and frankly, Your Honor, you know, when I came here today to say to the court,
now the
I'm
next-
not disputing that at this
So
point.
the next step is, then it would seem to me, whatever kind of hearing is contemplated under 5306C.
I think that's right, Your Honor, but I also think I would just caution or hope that this court would take into consideration not expanding beyond, the substantive rights of an interested person, keeping in mind that the rights in this case
Not
are
an
the rights of the
intervention into
incapacitated
the
person.
guardianship proceeding in toto.
That's right, exactly.
And then just to make sure I'm clear, your view is that a grandfather may be an interested person, but not solely because of biology. They'd have to show a relationship above and beyond the biology.
Well, Your Honor, I guess the only problem is that the statute is extremely broad. So the statute basically states, I believe it's any person who has interested in the welfare of the incapacitated person. So frankly, if it was my choice, I'd have the legislature try to refine that a little. Even in the amicus brief, the author of that brief tried to refine the category by indicating family member or close friend, but there's nothing in the statute
You don't
that
think
says
it's
that.
the last sentence that this comes under, of the definition?
You're talking about
I'm talking about
5306?
124.
Oh, of the definition of interested person.
Yeah.
The meaning as it relates to, well, I agree with that, Your Honor, but the problem with that is it doesn't give a whole lot of guidance. It's a
I
very
understand that. but
open-ended
That's
category.
what you have a
My-
hearing about.
Right, but if I had my druthers, I'd like to have the legislature give a better definition of what constitutes an interested person, but I certainly think for purposes of the statute and a petition to limit, it's clear at this point that that's pretty open-ended. But I believe the problem, Your Honor, is that this action wasn't brought under that statute. It was brought under a motion to intervene, and under the rules of intervention, I don't think that grandfather should have been permitted to intervene either by right or permissibly, and I believe that in that regard, the appeals court ruled correctly.
Great, thank you.
Thank you very much, Your Honor.